All
Okay.
right. Yep. Just once again, good evening and hello everyone. Welcome to this session again. It's a very big privilege to see Ansar Ismagulov here. He is our previous coach of Maqsut Narikbayev University. With the support of Minister Ansar, we made a very good result during our journey on Vis Moot. And I'm 100% sure that his expertise in this sphere is going to benefit not only the team of Maqsut Narikbayev University, but also the students who joined us today. And I hope you will enjoy the session. And Ansar, floor is yours.
Well, you're being kind to send. Thank you for such an introduction. I wasn't expecting it, but now stakes are high. And well, before we proceed, I would appreciate if this today's meeting, not a lecture, will get into the discussion stage, because the topic that I was given is pretty technical, and it will be based on the experience that I had. I'm not sure if it will be as useful if you won't be sharing yours. So in the course of my lecture, I would appreciate if you will be commenting or just asking questions or just generally chat with me. Yeah, so with that being said, let's just start. So right now you have to see my slides by now.
No, we cannot. No, yeah, okay. Now we can see it.
What about now?
Yes, we can see that.
I cheated a bit, but sure, I cheated a bit because I was given topic to discuss with you arbitration again, but I decided that it's too small for me, and I decided to speak about uniform law as well. And it seems to me it will be useful for you at this stage, because you have to keep in mind that half of the scores that you will be given in the visit will be based on your knowledge of uniform law. And my advice at this stage for you will be not to focus too much on arbitration, because I mean, again, it's just a half of the things that you have to cover during the visit. And with that being said, before we proceed, I saw that Usian sent you homework on Friday that you had to complete by today or yesterday or something, and I'm pretty sure that you did use something that I will be speaking about. And at this stage, I also know that Simbat and Madiar and Timuran is being drilled right now with Hussein for a couple of weeks on by doing research on various topics, not limited to arbitration. So all three of you, can you please share your experience that you had researching on these topics? Because I think that based on my experience, the research that we have to conduct is different than those that we have to do when we research on our domestic law. Or okay, I see Madiar is nodding his head. Yes? And I'm sure that Madiar wants to share his experience by unmuting himself.
Yes, I just gave him permission. You can talk. Yeah.
Do you hear me? Yeah, of course, because in our legal systems we don't study so much case law, but in arbitration and in common law countries, case law is pretty much everything. So I really struggled in finding appropriate cases, actually, because sometimes it's pretty hard to find the appropriate ones that can be suitable for your legal problems and for your legal justifications and for your legal arguments. I use some services such as CISG Online, for example, and Cloud, and some of the others. Yet I'm not sure whether I'm doing it correctly, because it's very time consuming, and maybe you have some advices, Ansar, on how to optimize the search.
Sure. I do have such advices. Yep. Yeah. But we'll be speaking about it. It's a great question. It's a thing that I'm struggling myself. I'm not sure if you can actually master this skill. The things that we have to do is just to try, and I will do my best to help you today. And Usian, so my guess is that you restricted everyone to to speak unless you give them permission to do so. Is it how it works?
Well, Sambat and Timberland now has the authority to speak, but other
Sure.
than that, all of the participants are muted. If you guys have any questions that you want to raise by speaking on the mic, you can just raise your hand, and I will just unmute you.
Okay. That suits me. And Sambat, sorry for interrupting you.
I think I can share some experience as well, some thoughts as well. When we researched for some cases about the CISG, it was somehow difficult, and I tried to find some sites with cases that other people already studied to help myself to understand the system and how it works, to find some like numbers of the cases, and then I can like write and type them on the cloud and to read the whole text of the decisions. I just found one of the ways to find some cases, and if we just like find some cases directly in the cloud, it is somehow complicated, and I think that needs an experience and training, yes, because as you said, you cannot master that skill. I think that's all.
Okay, that's great insight. And Sambat.
Okay, can you hear me?
Sure.
Okay, so yes, researching is a little bit hard according to case law, but in my experience, I try to search the cases and appropriate cases to some problems in the previous in the past memorandums of the Vis Moot of the previous years, and I try to find an appropriate problems to the different legal case problems in the Vis Moot and so on. But yes, I am also really interested in this topic and how to do researching more clearly.
Okay, yeah, I see it as well. And well, I guess unless anyone has other problems not related to case law, we can proceed. Again, if you do have some problems, just raise them and we can discuss on how to deal with them. I will address cases a bit later, and when it will be a bit more structured in my presentation. But I did hear you; it's pretty interesting because yeah, I had similar experience. And can I ask Milana, if you don't mind, to just review the things that were delivered to you by Eric and Ivan, because to be honest, I was not following everything that was done in this summer school. So I'm not sure what you already know and what you still have to research on.
Yes, sure. For our 3 lectures that was previous, there was more about basic things. For example, what arbitration process is, how does it work, institution of arbitration, also experience about Vis Moot, how it's better to show yourself, how to present and speak. It's more about interactive things, but the first 2 lessons were more about arbitration in general.
So can you say that by now you do have some idea what arbitration is about?
Yes, sure. We already series is previous.
Okay, so my guess was right because I was not focusing on arbitration for this particular presentation, and we can just jump into the research. Before we do that, let's just ask, it will be probably my last direct question to you. Did you hear the term uniform law before this summer school or before this lecture?
Are you asking me?
You asking me? Now it will be a question to you. Yeah, you have to answer.
Maybe you talk about the uniform law, like to make provisions for different countries and different jurisdictions the same. Like I heard about UniDroit, and that they want to make some uniform law for like many jurisdictions and many people. Is it that you're talking about? Is it uniform law?
Yes, that's perfect example. So my guess would be that before you apply to these activities, uniform law was in the same way alien turned to you as arbitration, right? Well, I bet it was quite alien for you. Well, I see Madhyar is not with me on this point.
I don't know, for me, like uniform law is like conventions, like CISG, it's like uniform law.
Yeah, it's all uniform law. It's an instrument of uniform law. It's a conventions. It's a text of unification. It's even draft conventions. It's a draft instruments and so on and so on. It's whatever it is that tries to uniform the law across multiple jurisdictions. Model law for potential adaptation. Yeah, sure. Yeah, it is. So I'm glad that you do have some idea about it as well. But I'm not sure if by now you do acknowledge the relevance of this uniform law for you. Because, well, I actually realized it pretty recently. For me, it was just learning the language of aliens when I was learning something on uniform law. But you have to acknowledge that functionally in private law, different jurisdictions view it more about, well, it's about soft law as well. Sure. Different jurisdictions functionally view justice in the pretty same way. Well, you don't need to be Chinese or European or Kazakh to understand just that good is good and bad is bad when it comes to private law. But the thing that you will be noticing is that we do achieve justice by different means. We may apply good faith or we can apply implied terms. We can call it estoppel or we can call it venire contra factum proprium. We do use different means, but in general, we do get into the same result. And this functional view on uniform law may help you to understand that to know how to get into this result is probably one of the most important skills that you may have to sell to your employer or to your client. Because when you will be practicing law, you will notice that sometimes the means to get this justice are not convenient. They are too expensive, or you have a corrupt judge and whatever. But when you learn uniform law, you learn how to see different ways how to get into this result. I'm sorry for speaking in such an abstract way, but it's the things that I'm noticing in my work. Because whenever I am drafting something right now, some briefs, I tend to, I cannot hold it in myself just to refer to German stance on something, on how UK Supreme Court deals with this issue. And it's not because I'm so smart, it is because it's easier for me to find this answer in different jurisdictions, because they do have a much broader discussion on these topics than we have. Unfortunately, we don't have such a Supreme Court that will discuss issues that are being discussed in UK Supreme Court. But when you get this understanding that the justice is pretty much the same, it's just different means to achieve it, you learn to apply it in the context of your domestic law. Again, sorry for explaining it in such an abstract way. It's a new thought for me, so it's not that coherent from my side right now. But what I can promise you is that by researching within the Vis or on your own uniform law, you will start noticing that you actually can work on a much broader range of issues. And I guess at this stage I can refer to Usian and me, and Jasmine as well. I guess we are only three mooties in this call right now, is that we are not afraid to delve into foreign law. We are not afraid to just dive into it and try our best to establish the content of it, because we actually did the same during the Vis. So whenever me and Hussein have a task from our seniors as to the research on, let's say, UK law, we are not afraid to do so, because we know that, well, it's not, you don't have to be a god, or you don't have to be born on Ireland to get the knowledge of this law. We have a fact law. Sorry, because I can see only people with cameras on, and sorry for not noticing them. It's great to see you as well. Please jump into this discussion, because I'm not sure what I'm speaking about, so I would appreciate some help from your side. So when it comes to our domestic context, you have to appreciate that by learning how to apply uniform law, you can then work on AFC law, which is most relevant for Kazakh lawyers and probably for some Central Asian lawyers, because it's practically okay. I wanted to say English law without balls, but I don't want to say so. It's a pretty much adaptation of foreign law in Kazakhstan, and you have to know how to apply it. And the same goes to united to law of two centers, the AFC and the GM. They're also based on this UK law, and well, you have to keep it in mind. That's why it's so important for you. And the other thing is that when you will be researching in it, you will upgrade your skills of analyzing the doctrine, because again, you will not be limited to the doctrine of your domestic country. You will not be limited to few articles of Suleimanov, maybe to articles of Professor Nesterova, that will be discussing pretty much the same issues within their range of understanding, but you will be tracking the discussion on transnational level between German professors and US professors. They will be agreeing with each other, with their countrymen, or disagreeing. And it's also to be in this discussion. And well, but it do require some prerequisite skills, which I'm sure you do have. So the basic one is to know the English, and it may propel your understanding of doctrine as a whole. And yes, and it's very, very instrumental when it comes to submissions to the higher courts and to the courts that may put some brains in deciding the case. For instance, when we do apply for a couple of months ago, when we applied for appeal in AFC, we faced with an issue that UK judge, pretty stellar one, he's too used to apply his own law, and he cannot give proper understanding, and he cannot properly acknowledge the context of Kazakh law. And when we did draft our appeal, we heavily relied on comparative analysis of two legal orders, and it was awesome. It is the appeal that I'm most proud of so far. And it was just so beautiful, because you actually can see the conflict between two systems, and you actually, by the end of the Vis, you do have such skills to distinguish between two. Well, it may seem obvious to some, but it was not obvious for me at all. And when I did realize this feature of uniform law, I do invest all my time as I have to actually research on uniform law, not on arbitration, because it seems to me that arbitration is pretty much, well, it's too instrumental to be useful, to be as useful as uniform law when it comes to developing your reasoning as a lawyer. And well, I hope that you will get this feeling or similar feeling, or you will find something useful in uniform law as well. With that being said, sorry for such a lyrics. Within the context of the Vis, you will be working with probably 3 sources of uniform law. The first and the most basic one is CACG, which I'm pretty sure at least half of you already heard about. And the thing that you have to keep in mind about CACG is that it was one of the first conventions to be quite successful in uniforming the law. And well, the things that they did, most of them were a compromise, but still it was a huge step at that time. And again, when you'll be researching on these instruments, you have to keep in mind that it was always a product of compromise. They had a real-time discussion between lawyers from different jurisdictions, and they actually had arguments how to better draft the legal instrument. Because imagine 80-year-old professor from Yorkshire arguing with 60-year-old professor from.
Ansar, I apologize. You have some connections issues. You're lagging.
Is it still the case right now?
Well, you lose your connection by time. Like sometimes you have a very good connection, and sometimes you have interruptions for a couple of seconds.
Is it me or is it Hussein? It's specific of Almaty.
We can hear you now.
Okay. Well, Madia, can you remind me or when did you lose me?
You were speaking about the CISG.
Okay. So, you have to keep in mind that CISG was one of the first instruments that were quite successful in uniforming the law. And again, when you'll be reading the convention, you have to keep in mind the context behind this convention. And I don't know, I like to imagine 80-year-old professor from Yorkshire, from UK, arguing heatedly, getting personally attacked by professor from Italy, with all the features that angry Italian may have. And they actually had such live discussion on the law that they were drafting. But they did drafted pretty awesome conventions that we do apply now. Unfortunately, Kazakhstan is the only country within this region that didn't ratify this convention, but it doesn't make it less relevant, because again, it will teach you how law operates. Especially, well, at least in my case, it helped me to understand how Nachrist works. It's one of the instruments of German law on how they deal with termination of contracts. And it's actually the way we probably deal with termination of contracts within our special part of civil code when it comes to certain types of contracts. The same way, they also explain why we don't consider such things as causal or consideration to be serious when it comes to contract formation, because this bunch of old people in 70s already acknowledge that consideration or causa are not that important to form the contract. And these discussions, again, will help you to understand your law and how it operates. Yes, and you will be mostly applying it during the Vis, because it's a main convention of the Vis. And the second instrument is the instrument that was mentioned by Timirvan. It's UNIDROIT principles. In the same way, it was drafted by delegation of professors from different jurisdictions, and it probably the most successful instrument of soft law because we can even see the contracts being fully governed by UNIDROIT principles, not by national law, which speaks volumes of its relevance. And the third type of legal instrument, it will depend on the case that you will be facing. During the MyVis, my 2 seasons. The first season we had Hague Convention on Choice of Law agreements or something, 2005. I'm not sure if it was 2005 or 2012. I'm sure Mohammed would know way better than me and answer to this question. But my second season was very practical when it came to the legal instrument. It was United Convention on against corruption, and I'm most proud to apply it when it comes to Kazakh clients, because Kazakh clients tend to be dirty or to be somehow related to corruption or being victim or not exactly victim of corruption, and it's a very useful convention to know. And I'm just lucky that I had experience to research on it during my vis. I guess when Hussein was a mootie, he also had quite extensive research on the conventions that governed electronic commerce. We have quite some of them. Yeah, and he also made a almost PhD research on certain conventions that he can refer to right now, right, Hussein?
Yes, it was about GDPR. So it's basically Data Protection Act of the European Union, which is structured very well to protect the personal data of people. And our main problem in the Vis Moot was related to the cyber attacks. And due to the fact that data breach and the personal data laws are not that developed in our countries, we had to read over 30 books in order to find answer to a single question. That's why what Ansar is trying to say is that each year you're going to have specific conventions, specific issues on which you will have to make a very deep research in order to get a high scores from the arbitrators.
Yes, and pronouns, but again, I was feeling right.
Yep.
Okay. Oh, you didn't lose much. Okay. Well, with that being said, you will basically have 3 main sources of research when it will be the vis season. Yes, and the sources to study the law is, for me, I was trained in that way that you have to first look into the textbooks and then to read specific case law. I'm not sure if it's uniform way on how to learn law, but it's the way that I was taught to, and I'm pretty sure that majority of people in this room were also taught in that tradition, to first go into the textbooks and then to try to get into this case law. So I did highlighted only 4 books on this slide, and I guess if you can read at least, well, to be honest, I read only probably 2 at best, and I'm trying my best to get the 3rd one. I'm not sure if I will read it within my within my career in this firm, because I don't have time for it. But it's I guess trying is also counts when it comes to learning. So the first 2 books, they can give you great perspective on how law operates in different leading European jurisdictions. Unfortunately, only how private law operates. And the best starter, I guess, it will be the Kurt's book, the first one on the slide, because it's not that big. It's probably 500 pages or 600 pages. It's manageable amount, but it do give you a great overview on how law operates. It doesn't make an accent on instruments of unification. It may refer to them in footnotes, but it's not the focus of this book. So keep it in mind. But when you will be researching on uniform law, you will still see the reference to national law. Like we did accept this version of Unidroit because Italians think so. and in Italy it works. And it will be, oh, they will not explain how Italian law works. The only way to know it is to know Italian, which may not be the case for us. Well, at least for me. And the second option will be researching by using the books like Kurt's European Contract Law, because it do give a great overview of these jurisdictions. The second book is way more bigger one. It has probably 2,600 pages or so, or 200 pages. 2,000 pages, sorry. But it do focus on instruments of unification. So when you will be researching on UniDroit, you will probably apply it every time when you have doubts. Again, it's a great book. It's just the volumes of it is just insane. And this specific also handling Moscow commentaries for CCG. Moscow says it when I was completing which task. I'm not sure if I saw such tasking in the chat of this summer school. I have the feeling that it was one of Usien's tasks.
Yeah, one of the Usien's tasks. We was explaining about some articles of the CISG.
No, it's tough. It's tough. I'm glad that you do have such an experience. Well, just my condolences. Well, let's continue then. Yeah, and the two textbooks are related to the Vis directly. They comment on CISG and on UniDroit. Again, both of them are pretty. They don't have privilege to dwell into the topics deeply. They do give you a good overview on how things were adopted, why they were adopted, at least when it comes to UniDroit, and when it comes to Schwenzer, she is good when it comes to give a brief overview on how doctrinal discussion looks right now. Sure, she does have an opinion on things, but I wouldn't say that she writes it so broadly as to convince you. Sometimes she unfortunately just states her opinion, but when you will be researching, when you will be drafting the memo, and when you will be pleading in the Vis, you will notice that arbitrators will actually want to hear from you the reasoning behind your opinion. They may disregard the opinion. At itself, but they will appreciate the reason that you are giving to them. So you have to, unfortunately, find the sources that will actually give you the reasoning behind their opinion. And my advice at this stage will be not to limit yourself with opinions. That I'm trying to say. Just try to find the reasoning of this opinion. And unfortunately, these two textbooks on the slides may not give you this reasoning as that you are seeking. Yeah, the case law that you mentioned. So I did put on the slide some sources that you can find case law in. I'm pretty sure that at least 3 people in this call already know this website. And I guess the thing that you mentioned a bit is that you are struggling to actually understand the context behind this case law. I see somebody's nodding. At least how I view it is that every case law that we read is actually, we're reading only part of discussions that judges are having between themselves. To fully understand discussion, we actually have to at least know some context behind this discussion. We cannot just jump into discussion between two men and to understand them. Sure, we may get some parts of their discussion, but we will not ever get the whole meaning of it. And in the same way, you have to treat case law. You have to try to understand the context behind this case law. And it never is. It's impossible to make this process easy. My advice to you would be to try to understand the legal tradition as a whole on how judges operate in these countries. For instance, it's pretty hard to read the judgments of French Supreme Court because the type of Supreme Court that they have they do not have privilege of drafting complicated and detailed judgments, because how their cassation court works. They review every case that they receive. And it's in great contrast with German Supreme Court that actually do have such a privilege. They do provide a detailed judgment. And for instance, to form a position in French Supreme Court, you have to have at least a couple of decisions that gives the same, that will produce the same judgment. Because when you do have such a cassation, it's just sometimes impossible to ambiguously state the opinion on the law. And it's only a small fracture of the context that you have to face when you are researching on case law. Another advice for you will be probably, before reading the case itself, maybe try to find the commentary on it by professors or by law firms. I know that some people tend to read UK judgments as a whole, but I'm not such a person. I'm doing my best to find easy explanation of this judgment and then to read it myself. I cannot see any other way how to deal with it, because it's just generally hard. And well, you have to acknowledge it, and when you will be researching it, particularly in the context of uniform law, you have to distinguish when judge applies his law, his national law, and when he applies the uniform law. We had such a case with in the previous season. We had judgment of Netherlands Court of Appeal. Yet it was Dutch Court of Appeal, and by the end of the week, we were not sure whether Dutch court applied uniform law in abstract way, or they still had in mind their own law. And thankfully, we were not caught on this question, but still, some things are just being left to be unresolved. It's a matter of how things works, because remember that judge decision to actually create a law in their own country, to create uniform law is not their first priority at all. So you have to always remember the national context behind every case law that you're reading. Another feature of research in uniform law is that you have to also acknowledge the debates that they had when drafting these instruments. One of the means how to get this idea is to research on reports of working groups. And again, I can refer you to Lucien, who did an excellent job of finding the particular part of the discussion that was most relevant to our previous Vis problem. And I did my best, and it's actually great when you see how mooties can even, sorry, I will put my slides off. And it's actually great to see when mooties can navigate between these discussions, because again, it's a discussion and it's can be subject to different interpretation. On this regard, I can refer you to the reading that we had in Astana. Yanis, I, and Feridun were arbitrating the round between Vienna and Mainz or something, and she actually convinced me that my understanding of the discussion of the delegates were wrong. I'm not sure if she is right, but she managed to provide me the reason behind this discussion. What I'm trying to say is that even these reports are open to be discussed. And your task again is to be critical, to analyze them, and probably, which is probably even harder, is to be so eloquent as to convince third parties that your understanding of this controversial report is right. And it goes to everything in the Vis, both on written advocacy and oral advocacy. With that being said, I was not expecting my lecture to be so abstract. Sorry for that. I suggest we have probably a 10-minute break, and then we can continue discussing the things on arbitration and other technicalities. So let's meet in 10 minutes in 49. Yep.
Okay.
Sure. All right, we're back.
Speaking of the context behind law, I just recalled the pleading that we had with Vienna team. Do you remember that they actually brought the case law by hoping that we don't know the context of it? And when they actually brought it, Usian did embarrass them by pointing out that Austrians cannot apply their Austrian law properly, that they ignore the context behind the judgment, and it was bad. And when we had a chat with these mooties, they they did admit that they were hoping that we don't know the law and it will work, that we will not notice it. So I guess it's a great example why you always have to know the context behind every case law. So, as that being said, we can now start to discuss research in arbitration. And given that both of your lecturers so far were common law trained lawyers, I bet they didn't discuss with you these things listed on my slide. Is that more or less the arbitration and how people view the arbitration can be summarized in these 4 groups. And when you will be researching in arbitration, you have to keep in mind that the author or the judge that you're reading right now is probably may relate to the following groups. So the first group is probably the most widespread one, is the ones that view arbitration as just one of the type of contractual relationships between the parties. And the scholars of this group they put great emphasis on the party autonomy. By referring to party autonomy, they think that parties can get away with many things. And well, it's again, they are not wrong, it's just one of the view. And it's like a political spectrum. It's in the same way. Some people are more or less have one of these views. The second one, the jurisdictional one, is, for me, it's quite surprising, can be seen when it comes to common law and common law judges, because it seems that they view the arbitration is as some form of jurisdictional process, as they do view arbitrator to be as sort of a judge, as the thing that at least my senior likes to refer to is the section in Arbitration Act 1996 that may provide setting aside the award if arbitrator misapplied the law, which is outrageous for people from the contractual school. So that's, you have, again, it's the things that you may have to keep in mind. It's not that visible when you doing your general research, but when you will be facing with the discussion in the doctrine, you may get the feeling that the problem is that conflicting authors are related to different schools, and this understanding may get you some clarity. And in general, the main task of mine today is to give you some clarity, because Oh, it's hard to get it, but you at least have to pretend that you do have this clarity when you will be researching. To understand case law. Again, the things it relate to the legal tradition. And on the slide, I put my favorite cases that it was decided differently in two relevant jurisdictions. So, as you may know by now, arbitral award may go through setting aside and may go through enforcement proceedings. And setting aside is proceedings that are being held. What was the first one? I missed. I will send you this this presentation, and you can see the fourth school relate to the school developed by French professors. To my knowledge, it's not that widespread as the first two ones, and you also can get the details of it, at least the overview of it, in Gary's Bourne 3-volume. In the first volume, he do have a bit of overview of the doctrine on arbitration. Again, as we discussed, the arbitral award can undergo both setting aside and enforcement proceedings. And most probably, both proceedings will be held in different jurisdictions. It's not uncommon when the award was not set aside but was refused to be enforced in two jurisdictions. In our case, we had two developed arbitration-friendly jurisdictions, France and United Kingdom, but they did have different legal tradition when it came to the interpretation of arbitration agreement. In the case before you, the arbitration agreement did not provide the applicable law to the arbitration agreement itself. So the issue in front of both French and UK judges was what law applies to the arbitration agreement. And the answer to this question was decided when it came to the validity of the arbitration agreement. So under one law, it would be invalid, and under the other, it would be valid. And again, French and UK judges applying their legal tradition differently resolve the case. The French Cour de Cassation upheld the arbitration agreement and refused to set aside the award, but the UK Supreme Court refused to enforce it by finding the arbitration agreement invalid. This case was developing when I first applied to the Vis, and it was for me the biggest nut to crack. By the end of the Vis, at my Vis, I couldn't crack it because it was so hard for me to acknowledge that both courts inherently had different approaches to interpretation of law. And on the hindsight, I would appreciate if somebody during maybe the summer course would tell me that the most important part of understanding the case law is, again, to understand the context. How I could understand the context in this particular issue. I could Google and read the previous judgments, previous decisions of both respective courts. And, well, by doing so, I could presume that Supreme Court will continue his position in the relevant case. It was unfortunately true in both cases. If I could correctly understand the previous judgments, I would not be as confused as I was. So I would appreciate if by the end of this lecture you will find the time to Google both of these decisions. They're really awesome, and it really gives you the perspective on how, again, law operates. Yep. And unfortunately, when this case was developing, we had no textbooks that discussed this case because it was developing on site. It was just I guess this problem was published a couple of months later than later of these judgments. And it's the most awesome part of the Vis that you have to actually think on your feet, which is not enjoyable, but still it's pretty awesome for us as lawyers. Can I clarify, did you understand the drama of this case correctly or not? Could I establish it properly? I guess.
Yeah, I think I've got it.
Okay. And again, arbitration for you right now, especially after the lecture of David, may seem to you pretty technical. It may seem to you just as a bunch of legal rules that you have to keep in mind that somehow somehow they apply differently. But you have to get through this feeling and find the time to learn the very basics of arbitration. Because as you will see, one of the leading commentators in fields of arbitration are common law trained lawyers, and in common law they treat law as a band. Well, it seems to us that they treat law as just a compilation of rules. Sometimes they don't struggle to give you this systematic. You may not get the systematic understanding of law when you will be reading authors from common law countries when it comes to arbitration. So that's why I highly encourage you to find these purely doctrinal works on arbitration to get the reasoning behind how arbitration law works. And surprisingly, one of the sources for such understanding may be the course on YouTube by Gary Borg. He published his Am I audible?
Sometimes you are freezing, sometimes.
Okay, so what I was trying to say is that you should try your best to understand the very basics. Don't skip them. You will not waste your time if you
Ansar, can you hear me now?
Hmm?
Seems like you have some issues with internet again. Can you say something?
So am I audible? Because the thing is that I can see you on my laptop, but I see that I'm freezing on my phone.
Now it's perfect. Now it's perfect. We can hear you, we can see you. You're not lagging.
Oh, okay. The Murphy law is that today we have a technician who is fixing our Wi-Fi, and he's making the thing work worse. I'm not sure how it works, but it is the case for me today, and I apologize for it. It should not be the case for you. Well, again, you will not be wasting your time if you will spend some time of it on the basics of arbitration, because again, the majority of the issues that you will be researching in the Vis will not be unambiguous. It will be the issues that are not resolved yet on the level of doctrine or in case law. So the only way on how to answer to them is just to understand the basics of arbitration on your own and to provide your reasoning on how law should operate. And I mean, unfortunately, it's the hardest part to know the basics. And I'm for the couple of years I'm being mentored by my senior who is a fan of these basics. Every research that we have on the very technical topic, it may relate to financial law or to contract law. It always comes to the very basics of the law, and these discussions of the basics of the law are the hardest one, on my experience. And in this discussion, the only thing that you can develop is your reasoning, and the reasoning is again the thing that everyone is looking for, not only in the Vis, but I believe in the work as well, at least my seniors. I'm not sure about Usians, but I did met some. I believe it's also true for him. So again, I'm not sure if you hear it for the first time. You can check the lectures of Gary Bourne. He do provide some comprehensive course on arbitration. I wouldn't say that it is the best one, that it's so underwhelming, but at least it's coherent. And well, it's also good when you learn it for the first time. Probably the most useful slide for you right now is that there are plenty of sources for the Vis. This laptop doesn't contain as much sources as I would appreciate, but when you will be working on the Vis problem, you'll start noticing that people actually share sources with each other. We have a couple of professors that every season they post the cheat sheet with links to the primary sources of the Vis. Usian will send you when it will be your season, and Afak as well. So, but for the purpose of this summer school, you may learn the three sources. The first one is all illegal websites that you can find on the web, and that, well, you have to, when you'll be using them, you have to solve this moral dilemma whether or not you want to get the source or whether or not you want to be true to the law. I'm not good at intellectual property law, but I believe it's to be legal for students to use such a website under fair use law, under fair use or something. But well, to my knowledge, I didn't hear about anyone to be sentenced to the prison for using these websites. And my favorite one is that library. Unfortunately, this website is being prosecuted by FBI and by some European agency. I'm sure unlawfully prosecuted, and so they always change their website. But when you will be carefully Googling it, you will eventually find it. My only advice for you will be, when using it, don't use your corporate emails and don't use at all your law firm's emails, because who knows, maybe you'll be hacked, and well, you don't want to be hacked because you wanted to download the book. So find your forgotten trash emails and use them to log into these websites. It's really worth it, because all 4 books that I put on my slides are all available in this website. Yes, and VPN, but I'm not good with VPN, to be honest. So I cannot recommend the things that I can do on my own. So, but Jasmine, she does seem like a person who uses VPN. So yeah, you might ask her. The second advice is to actually go to YouTube, and you will notice a couple of channels that put great lectures on the Vis, especially the channel called Africa in the Moot, or in the Vis Moot. In this season, they showed awesome lectures with many professors and practitioners. Some of them are really, really good. I would personally recommend the lecture on advocacy held by some US practitioner lady. and she was very, very specific and great when it comes to instructing on how to advocate in this. And the third source that I was actually discovered during my work here is that you can, only for 50 euro, you can get access to the Cleaver. And Cleaver is probably one of the most expensive databases, legal databases out there. I know that some law schools in US cannot afford to have a subscription for Cleaver, but you actually can have by buying this Palace library subscription. So when you will be buying it, you can then go to their website. They do have access to ridiculous amount of these e-libraries, including Hain, GSTOR, and etc. Well, the most relevant one for you will be Cleaver. So let's just see how it works. Let's say I need the book of Professor Born, the most famous one. Book. So they actually do have it, both hard copies and e-copies. And by clicking this button, alternate links, you can actually see the websites that you can access to with this book. So you have to choose the Cleaver, this one, Cleaver Arbitration, and by clicking it, you get access not only to this book, but to the Cleaver as a whole, which is I don't know how to express my joy when I discovered this feature myself. And it again costs only 50 euros. The thing is that you have to log in through your personal email, so it should not contain anything corporate in its name. For the book of commentary for the book, well, I'm not sure if it's a Bible already to be commented on. But yeah, you actually can see it's actually. I guess I get what you're trying to ask. Unfortunately, no, we don't have we don't have even a forum on where they would discuss this book. The only way on how to get the commentary on it is when someone is directly referring to the Gribor. That's all. That's the only way how to know what someone's saying on Gribor. The comments that I received on Gary Born's book is that he's probably too arbitration-friendly author. He will be advocating for arbitration and for its freedom and for its scope every time when he can. So his opinion on some things are pretty. Yeah, well, he's consistent, but he's consistent on that. And actually, if you want to find the counter argument to Born, you probably may remember that you may probably find the author that have some different view on a broader scope, like someone who thinks that arbitration should be restricted a bit. Maybe by doing so, you actually find someone who will be maybe not referring to Born directly, but to the ideas of Born. I guess that's one of the way on how to get the commentary on Gribor. And again, I guess you can also try to use Bailey. It's a database of UK judgments, and they may directly refer to Gribor. But to my knowledge, they mostly refer to him to prove their point, not to discuss with him on the merits. So it's a pretty tricky question, and well, again, that's how the doctrine works. You just have to find the other opinion, or develop your own opinion. Again, it will fly perfectly. It was great to see him, Hussein. Sorry. I guess sorry for not making it interactive because I was a bit too excited to discuss these issues. And again, I guess you get it that I love abstract things. And the very first thing that I said to my team in the previous seasons that you have to compare your work with Sisyphus because it's just never ends. And sometimes all the time you feel confused. You will have this gut feeling that it never ends, that it doesn't make sense, that the opinions that you found is being criticized or does not meet support in case law or in other works, and this feeling is all right. It doesn't make it easy, but at least you have to keep in mind that thousands of mooties out there is feeling probably the same thing. And in contrast to Sisyphus, you are not alone in this never-ending struggle. There are thousands of you that are trying to put this rock on the bottom of mountain, but it's just impossible. And well, it's a great feeling, I think, to realize it and just to be happy with this struggle. So I don't know, just be happy when you'll be struggling with it. That will be my probably most important advice. I know that the lecture that I'm delivering right now is not as coherent as it should be, and it's pretty technical, and it's just hard to discuss with you. But I guess you may get the idea that I'm trying to say. Yep, that would be all, I guess, on my side. And by the way, yeah, I actually, when I was asking permission from my seniors to deliver this lecture, I promised that I will pitch my firm a bit. So in order not to lie to them later, I'm pitching you my firm. It's a great place for you to actually practice the things that we discussed right now. And if you're looking for the place if you're already looking for the place to practice later on, you can always apply to this firm. Docs, Google Docs. Yeah, let us send something in the chat. Should I fill it as well?
Well, this is just an attendance link, and whoever attended the lecture just can fill the form. And if you guys have any questions to Mr. Ansar, you can just go ahead and ask them. I just made it possible for everyone to turn on their microphones. So.
Oh, I was pretty active in getting the questions in the beginning, so I will not be surprised if you don't have questions at this stage, which is again all right, given the technicality and given the technicality of the lecture, and that it was practically based on my experience. By the way, Violetta, I see you, and I see Jasmine, and I see Hussein. At least I see you, so I'm sure that you, as I had pretty the same experience when it came to researching in the Vis. So can you maybe add something to what I said, or maybe disagree with something that I said, or just provide anything useful for these students? And I see Zuhra to turn your camera on. If you want to ask a question, go on.
Actually, I'm sorry, if I can answer, I can ask a question.
Sure.
Can I ask about not arbitration, but most about your work? So you as an junior associate in the Tukulov firm, do you what do you do mostly? You draft documents, and do you attend the courts or arbitrations, or you need to get experience to get to the courts?
I'm afraid to disappoint you, Timurwan, but I'm not junior associate. I'm paralegal in this firm, and as a paralegal, probably 70% of the work or 80% of the work that I do is probably research or drafting something. Probably 20% is just doing some technical work or to coordinate the technical work that are being done by interns. And yeah, I do enjoy it, and most of the time I assist on litigation matters, both on domestic and AFC court. Yep, and I would, well, it doesn't fit for all. So the advice that I received from my seniors for these couple of years is not to be sure that you want to apply for DR, for dispute resolution. Probably is the better ways to get to know all practices and then to decide where do we want to practice. And
Okay.
I don't have, by the way, I'm not eligible to speak to speak in courts, to advocate on behalf of clients in courts, because I don't have bar membership. But in Kazakhstan, it's not that hard to get it. You may find the bars that are pretty liberal when it comes to granting the membership. So, but in my firm, it's just no use for me no use for my seniors to send me to the course, because I have great seniors who are way better at it than me, and it will be the case for a couple of years, and it's pretty normal for majority of firms. Usually, you do a couple of years of. You usually don't go to the course within like first years of your practice. That's true for probably all decent firms in the market. Because pretty much sure. Which kind of works cover your work? Starting I'm not sure if you need to know much things about arbitration to actually practice it, because I guess employers in Kazakhstan doesn't look at your substantive of knowledge on arbitration as much as you imagine. They're actually looking for pretty basic skills, something like accountability, responsibility, and just general adequacy of you as an employee. So be pretty sure that you will find the job if you are putting at least that you are trying at least. You will find the job that's relatable for me. So thank you for the question. Okay. Which kind of areas are mostly covered by your work? Well, as I said, I mostly assist on. Actually, yeah, the thing that I like about practice in this firm is the range of issues that I have to assist on. Is that within these 7 months, I did assist on investment arbitration, commercial arbitration, on domestic litigation, and on AFC litigation, both administrative and commercial one. And yes, the range of issues for dispute resolution team is pretty awesome for me. It's a bit challenging, but the range of issues is pretty broad. I hope I did answer to your question, and I'm glad to see new faces such as Miraz.
No, I don't really have questions right now. I understood most part of it. So.
Sure. Well, it was great to have a chat with you and it was. I am proud to see new faces, especially from my university, with all my love to my Central Asians, but still, you have to have some prejudices, right, when it comes to such things. And I hope to meet you, some of you, in Almaty in October. In any event, I will be around. So I'm sure I want to ask you what we'll be discussing, the pains that you will be experiencing when working in the Vis, when working on the Vis case. And I hope that some of the things that we discussed today will come to your mind when you will be working on the Vis, or when you will be practicing your in firms, or trying to get the content of foreign law. Because, well, sorry for being so talkative. Again, my advice, and sophisticated one, is to not to limit yourself right now at this stage. Don't be categorical by saying that I will be practicing only Kyrgyz law, I will be practicing only Kazakh criminal law, because I'm proud to have to know such persons that actually argued with me that nothing is cooler than Kazakh criminal law, and this particular person is now finishing her second master's degree in Germany, or in Rome, or something in some cool city which is way cooler than Almaty. So don't be categorical, and studying uniform law is one of the way on how you will be always be open-minded when it comes to research, when it will come to your plan and such. So I wish you all good luck. I really hope that for some of you it will be a great starter to study uniform law, which will bring you a lot of skills and benefits. And again, thank you, Ocean, for giving me stage, for putting students in front of me to speak on. I was not expecting it to be so enjoyable, and thank you all for your questions and for being such a great audience. Again, wish to see you all.
Absolutely. Thank you, Ansar, for being with us. It was very nice and informative lecture. I hope everyone enjoyed the knowledge that you gave them during this session, and most of the students will be able to use them during the selection process, which is going to be quite soon, and during the season of Vis Moot, which is going to be very important and interesting for all of them. And once again, thank you for being with us. Bye bye.
Yep. See you.
Thank you. See you.
See you.